What you're about to hear in the next few minutes could be the most important immigration update you receive this year. And the people most at risk right now are not the ones who ignored the system. They're the ones who did everything right. The ones who filed on time, the ones who've been waiting patiently, the ones who assumed that no news meant good news. If you have a pending green card application, if you're currently on a work visa, or if someone in your family is anywhere inside the U.S. immigration pipeline right now, this video is not optional viewing. Missing even one part of what we're covering today could cost you months, possibly years, possibly everything you've built. I'm Edward, and welcome back to U.S. Green Card Signal, where we track every meaningful shift in U.S. immigration policy and translate it into information you can actually use. Today is not a routine update. Today we're covering confirmed documented policy changes that are already affecting millions of people currently in the immigration system, and the vast majority of them don't know it yet. Stay with me through the entire video, because toward the end I'm going to walk you through one specific action step that could protect your case from the worst consequences of what's changing. That step alone is worth your full attention. The scope of what's shifting. Let's start with the actual scale of what's happening, because I want you to understand this isn't a minor procedural adjustment. Based on backlog data maintained by U.S. Citizenship and Immigration Services, USCIS, an estimated 4 to 6 million people currently in the U.S. immigration pipeline are positioned to feel the direct impact of these changes. That number reflects real pending cases across multiple preference categories. And what makes the current situation particularly significant is that several of those categories are being affected simultaneously. Normally, policy changes in immigration tend to be targeted. One category, one processing type, one country group. When multiple categories shift at the same time, immigration attorneys describe the result as a cascading backlog effect. Think of a major highway where 3 separate on-ramps merge into a single lane at exactly the same moment. Traffic doesn't just slow down, it compounds. And whether your case speeds up or gets caught in that merge depends entirely on which side of the new framework you fall on. Change 1. The filing date chart is being restricted. For anyone who has spent time studying the USCIS Visa Bulletin, you're familiar with the distinction between two charts, the final action date and the date for filing. Under the previous framework, when USCIS determined that sufficient visa numbers were available, applicants could use the more favorable date for filing chart to submit their I-485 adjustment of status application even before the stricter final action date became current for their category. This flexibility was meaningful. It allowed hundreds of thousands of applicants to lock in their position, obtain work authorization and travel documents, and maintain a greater degree of stability while waiting for final approval. The updated rules significantly restrict when and how USCIS will permit the use of the filing date chart. In practical terms, the window to file your I-485 early is narrowing, and in certain categories, it is closing entirely. If you have been waiting for an opportunity to file under the filing date chart, the time to act is not later, it is now. Change 2. Derivative beneficiary age-out protections are being reinterpreted. This is the change that, in my view, carries the heaviest human cost, and it deserves careful explanation. When a parent files for a green card, their children are typically included in the petition as derivative beneficiaries. The challenge is that if a child turns 21 before the green card is approved, they can age out of the petition and lose their immigration status entirely. Congress addressed this concern through the Child Status Protection Act, which established a formula to essentially freeze a child's age for eligibility purposes under certain conditions. For years, families relied on this protection, particularly those facing long backlogs, to ensure their children remained covered under the parent's petition. The new USCIS guidelines are reinterpreting how the age freeze calculation under the Child Status Protection Act is applied. For families who have been waiting 5, 10, or even 20 or more years, which is not uncommon for applicants from high-demand countries, children who believed they were fully protected under existing law may now find that protection doesn't apply in the way they understood. These are young people who grew up in the United States, attended school here, and built their entire lives here. A formula change in a policy document now places their immigration status in serious uncertainty. That is not an abstract policy outcome. That is someone's child. Change. 3. Fiscal year end. Visa reallocation is being restructured. This is the change that immigration attorneys are discussing most urgently in private, and it involves how USCIS sequences employment-based case processing near the end of the federal fiscal year. The U.S. immigration system operates on a fiscal year ending September 30th. Historically, unused employment-based visa numbers from certain preference categories have been reallocated at year end, and some applicants have benefited from these reallocations to receive green card approvals ahead of their expected timeline. The updated processing rules change how and when those reallocations occur, and critically, who is positioned to receive them. For some applicants, particularly those in EB1 and certain EB2 subcategories, the new framework may actually accelerate processing. But for the much larger population of applicants in the EB2 and EB3 backlogs who are counting on year-end reallocation as their realistic path to approval this fiscal year, that pathway has become significantly less predictable. I'll return to this point shortly because there is a specific protective step that addresses exactly this risk, and most applicants are never told about it. What this looks like in real life. Let me describe a situation that is likely to feel familiar to many of you. Consider a software engineer from India, let's call him Ravi, who has been in the United States on an H-1B visa for 11 years. His employer filed his EB-2 petition in 2019. He has watched his priority date move forward, retrogress, and inch forward again. He has renewed his H-1B 3 times. He has a US-born daughter who is now 7 years old. He has built a life here in every meaningful sense of the word. He believed he was 2 to 3 years away from his green card. When Ravi learned about these policy changes, he didn't freeze. He contacted his immigration attorney and asked one focused question, not, "Am I going to be okay?" because no attorney can honestly answer that, but rather, what is the current status of every document in my case file, and is there anything that needs to be updated or resubmitted before the new rules take full effect? That single question uncovered something that could have had serious consequences. A supporting document in his I-485 package was approaching an expiration threshold that, under the new processing timelines, would likely lapse before adjudication. His attorney was able to address it proactively. Had Ravi waited 2 or 3 more weeks, that issue could have generated a request for evidence, a processing delay of 6 to 12 months, and complications with his work authorization renewal. One question, one proactive conversation, potentially years of difference. The family-based side. I want to make clear that these changes are not limited to employment-based cases. Family preference categories are also experiencing significant turbulence. The F2A category, covering spouses and minor children of lawful permanent residents, had been advancing at an encouraging pace over the past year and a half. Revised allocation modeling under the new rules is expected to slow F2A movement considerably, particularly for petitions originating from Mexico, which already faces some of the longest wait times of any country in any category. For spouses living separated from their partners, for children growing up without a parent present, this delay isn't a bureaucratic inconvenience. It is daily life in a state of suspended uncertainty. And these changes extend that uncertainty in ways that carry real human cost. The F4 category, siblings of U.S. citizens, is facing what analysts are describing as a near-freeze scenario in several heavily backlogged countries. If you filed an F4 petition for a sibling and your country of origin is already facing extended backlogs, the new projections under the revised framework are not encouraging. Priority date advancement in these categories is not expected to be meaningful for the foreseeable future. The gap between announcement and implementation. Here's something that U.S. Green Card Signal focuses on that most channels overlook entirely. There is a critical difference between a policy change being announced and a policy change being implemented. Announcements generate awareness among people who are actively paying attention. Immigration attorneys, applicants who monitor the visa bulletin regularly, people already engaged with the system. Implementation generates consequences, including for the people who weren't paying close enough attention. The applicants who filed years ago and assumed the process was moving along. The ones whose employer's HR department was supposed to be tracking things. The ones who relied on a notification that never came. That gap between announcement and implementation is where most people get hurt. An unexpected request for evidence arrives. A case is placed in a hold status. Work authorization lapses because an I-485 was returned on a technicality the applicant never anticipated. At U.S. Green Card Signal, our purpose is to make sure you are never in that group. The one action step that can protect you now. Let me close the loop I opened earlier because this is the most actionable part of everything we've covered today. The people who get hurt by policy changes are almost never the ones who were completely unprepared from the start. They're the ones who did the hard work, filed the petitions, maintained their status, waded through the backlogs, and then got blindsided by one thing they didn't know to check. Here is what you need to do today, not this week, today. Step 1. Pull your priority date and compare it against the most current USCIS visa bulletin. Confirm exactly where you stand on both the final action date chart and the date for filing chart. Know which chart USCIS is currently honoring for your specific preference category. Step 2. Conduct a full document audit of your immigration file. Check expiration dates on every document. Medical examination reports, police clearances, civil documents, certified translations. Check the validity of your advance parole if applicable. Check when your employment authorization document expires and when you need to submit a renewal request based on current processing time estimates, which have shifted under the updated framework. Step 3. If you're working with an immigration attorney, send them a direct message today, email or phone, noting that you're aware of the current policy changes and asking them to confirm that your case strategy remains sound under the new framework. If you are self-representing or working with a non-attorney representative, cross-reference your priority date against the current visa bulletin and verify your understanding of how the new rules apply to your category. If your case is complex and you don't currently have legal representation, this week is a genuinely important time to schedule a consultation. The cost of a 1-hour consultation with a qualified immigration attorney is small compared to the cost of a procedural misstep in the current environment. These 3 steps won't eliminate the backlog or make the policy environment less volatile, but they will place you in the strongest possible position, informed, proactive, and protected to the degree that anyone navigating this system can be. A note on undocumented status and family-based petitions. One topic that has been coming up consistently in comments and questions directed to U.S. Green Card Signal involves individuals who are currently out of status or undocumented and have a U.S. citizen or permanent resident family member who wants to file a petition on their behalf. The changes to how USCIS is handling unlawful presence waivers and how those cases interact with consular processing timelines are significant, and they deserve dedicated, thorough coverage rather than a rushed summary here. Edward and the U.S. Green Card Signal team are preparing a full video specifically on that topic. If this situation applies to you or someone you care about, make sure you're subscribed to U.S. Green Card Signal with notifications enabled, because that video is coming soon and will be essential viewing. The human reality behind the policy. Before we close, I want to acknowledge something that gets lost in the policy analysis. Immigration is not a bureaucratic exercise. It is people's lives. It is families living in different countries waiting for a number on a government chart to move. It is years of sacrifice, planning, and hope. Every priority date movement, every processing update, every policy memo represents real human beings navigating one of the most complex systems in the world while trying to build futures that feel perpetually out of reach. If you are in that position, if you are waiting, if you are worried, if you are exhausted by the unpredictability of all of it, I want you to know that U.S. Green Card Signal sees that. And our commitment is to give you honest, accurate, actionable information that actually helps you move through this process with as much clarity as possible. Before you close this video, if this video gave you even one piece of information that you didn't have before you clicked play, please take 1 second and engage with it. It signals to the platform that this content deserves to reach more people who need it. If you're not yet subscribed to U.S. Green Card Signal, subscribe now. With the pace at which immigration policy is moving, staying current isn't optional. It's protective. And drop a comment below. Tell Edward and the U.S. Green Card Signal team which part of this update is most relevant to your situation, whether that's employment-based, family-based, or something else entirely. Every comment is read, and your questions directly shape the content we produce next. There is a lot more coming. Stay with us. This video is intended for general informational and educational purposes only. It does not constitute legal advice and does not create an attorney-client relationship. Immigration law is highly complex and fact-specific. Please consult a qualified, licensed immigration attorney for guidance tailored to your individual circumstances.